Hello and good afternoon. Welcome to week 17 of the True Normal. The name is Roelf vanderMerwe and I'm a director at vanderMerwe Robertson Attorneys. Just a special word of welcome to my three colleagues, George, Christel and Eugene Groenewald, also our guest speaker today. And to Theo Vorster, CEO of Galileo Capital. Theo needs no further introduction. He's been with us over the last 17 weeks and will again today facilitate the conversation with Eugene. And to Kees Snijders, CEO of Flickswitch, welcome. Kees will conclude and end our session today. As you all know, our session is an interactive platform. You'll be given the opportunity to ask a question to both speakers. We just ask that you state your name and the business you represent when asking your question. As mentioned at last week's session, the talk of the town in the South African business landscape is surely the Cape High Court judgment in a ruling where GUARDRISK must pay out the business interruption insurance claim by local restaurant CAFÉ CHAMELEON. My fellow colleague Eugene and Theo will in depth discuss this judgment and the possible impact of same in our business environment this afternoon. Let me introduce Eugene. Eugene studied a BC at the University of Stellenbosch, thereafter obtained a BC Honours degree in geophysics at Wits. He worked for 7 years as a seismologist in the oil industry, and while working, studied and obtained an LLB degree through UNISA. He's taken various insurance and advanced insurance courses through the Insurance Institute of South Africa. He completed a postgraduate international diploma in enterprise risk management through the Institute of Risk Management in London. Currently a director at vanderMerwe Robertson Attorneys, and Eugene is head of our National Insurance Department. For the past 20 years, he has represented insurers, brokers, and policyholders in insurance-related litigation. Eugene is also an avid trail runner and shows a keen interest in food and wine. And Eugene, unfortunately at this stage, the wine limited consumption. Eugene, we are looking forward to your talk this afternoon, and also our participants who are all in the business environment and without a doubt is scrutinizing the insurance policies and the fine print. Eugene, the floor is yours.
The basic business interruption insurance, which is based on physical damage. So it means there must have taken place some sort of physical event, such as a flood or a fire at the premises, before your business interruption will kick in. Usually what the policy state is that the damage had to be insured through the fire section of the policy, and also only against those perils. And if one of those perils causes the business to have a loss of income, then there will also be a business interruption claim if the policyholder had selected that section of the policy. Now it works with an indemnity period. That is basically the period over which the loss of income or drop in turnover is measured. And there's various definitions. It works either with the gross profit or gross rentals if it's a rental income company, or gross revenue if it's a services company. And then it also pays out for increased costs, also wages where employees have to be paid and they're not working. And then also you can claim for fines and penalties which a company may have to pay because it could not deliver on promises, on contracts. And as I've said, what you work with over the indemnity period, which the policyholders select, is you look at the turnover over that period after following the damage, and you compare that turnover with the same period in the previous year. So if the damages occurred in the months of June and July of this year, then you'll compare it with June and July's turnover of the previous year. And the reason for that is because businesses might be cyclical, and it's usually a good idea to compare it with the same period in the previous year. And then what they do is, how the formulas work is you take that difference between the two turnovers is multiplied by a ratio, a gross profit ratio they call it, which is basically the net profit plus all the standing costs, the ratio of that to the actual turnover. So you take out the variable cost, which would drop in any event if there's no business or become zero. Right. Then apart from the standard business interruption section, or part of that is various extensions which a policyholder can elect to take out or not. And one of these, the few extensions, as I said, there's a few. There's one, for instance, if there's a denial of access event, or you can even extend it to customers, you know, damages at customers or suppliers' premises. But one of the extensions that has crept into our policies in South Africa is the infectious disease extensions. And the Financial Services Conduct Authority in South Africa have recently identified 6 categories. I'm going to reclassify them basically into 5, because I believe one of them or 2 of them are very similar. But the 6 categories of infectious disease extensions, and now remember, the policyholder have to select this. So if you're a policyholder and you haven't selected whatever of these categories of extensions is available from your insurance company, then you won't have a claim for COVID, definitely, because the standard business interruption is just based on physical damage to the premises. Now, the 6 that the FSCI has identified are the so-called radius and notification category. Radius is one, a notifiable disease, and then on the next slide I'll show the other 2. But the radius and notification extension is the most common. The policies I've looked at, about 5 or 6, I would say, was 4 or 5 of those were of this category. So the trigger in that type of extension is that the disease must be either at the premises or within a certain radius. And the radius is typically range from what I've seen about 15 kilometers, 15, to 50 to 50 kilometers. There's also a proviso in these policies, and that's where the notification bit comes in. And that is that the local authority has declared that the disease is present in that area, or some say that, or some policies read that they must impose quarantine in that area, or have in some way restricted access to the area. So if you have the trigger and the proviso, you have a valid claim, or you comply with both. Then the radius category is simple. The disease must just be within that radius, then you've got a claim. And the notifiable disease extension is very similar to the first one. Also, the disease must be within a certain radius, but then the proviso is that there's an obligation to notify the authority that the disease is within the area. And that would usually happen from, let's say, a doctor that sees a patient is then got an obligation in terms of legislation to notify the local authorities. So that's that category. The next 2 is general exclusion category. Once again, the virus must be within the area. But the bad news is, if that disease has been declared or is of the nature of an epidemic or pandemic, then it's completely excluded. So in this case, if you're a policyholder, your policy has got a clause like that, you're unfortunately not going to have a claim, because the World Health Organization has declared COVID as a pandemic. Then the last of these categories identified by the FSCA is the closure or restriction or closure by order category, and that is the business interruption must have taken place due to notifiable disease at the premises, resulting in the closing or the partial closing by a state order or local government order. So this one is very difficult to prove for a policyholder, because it must have been closed as a direct result of the disease at the premises. And there's very few cases where I think that have occurred, or if at all. I mean, it might be that a business is running and they don't want to stop, whatever, and there's a disease in the local government by decree enforces the closure of the business, then that policy might pay out, or yes, it might be operational. Then just looking at the CAFÉ Chameleon risk, starting to look at it. In this case, the extension was the third one that I've mentioned previously, the notifiable disease extension. And before I look at the case any further, I also want to just mention that in the judgment, the judge made it very clear that each case will have to be decided on its own facts and the law. So it is very important not just to think, because what happened in this case now, it's going to be the same for all other policies, even if those policies contain a notifiable disease extension. Because within that category, there are huge, or there can be quite a wide range of differences, and the precise wording of that clause is very important. So it can happen that the two policies have similar sort of wordings, but just small changes in the wording can actually make a big difference. To illustrate this, I just want to show you an example of this firm, Corona Attorneys, who client came to see Mr. Corona, and before he could state his problem, the attorney asked him for a deposit. Say put down a deposit. So this client pulls out the business card that he received from a friend, and he says, no, but your business card reads, works on contingency, no money down. So the attorney, Mr. Corona, grabbed the business card and said, no, but the printing company made a mistake. In fact, it should read as follows: works on contingency, no, money down. So you can see in a simple case like this, what big difference 3 punctuation marks can, not punctuation marks, punctuations can do. And so here we've got a question mark, a comma, and an exclamation mark, and it changes the whole meaning of the clause. Now getting back to CAFÉ Chameleon, in this case, the applicant, CAFÉ Chameleon, was seeking a declaratory order against the insurer. Basically, what it means is it asked the court to state whether the insurer is obliged to indemnify CAFÉ Chameleon in terms of the business interruption insurance policy that was before the court. In this case, the court had to consider and look at the following legislation. And the reason I'm mentioning them at the outset now is because it goes basically, one of them goes really to the crux of the matter. The court dealt with the Disaster Management Act. It was in terms of that act that the lockdown regulations were imposed. And I'm sure most of you know that restaurants, as part of that, that legislation, those regulations, restaurants were closed completely to the public at one stage, and they're still not operating fully. Some other businesses were also closed completely. Only basically essential services at one stage could operate. Then the court also referred to the National Health Act, and particularly regulations that were promulgated in 2017, in terms of which a notifiable medical condition to be notified to local authorities were declared. And I'll get back to that. In this case, as I previously mentioned, the extension clause was of the type of a notifiable disease extension. And the trigger in that clause was that a notifiable disease occurred within 50 kilometers of the premises. And the definition in the policy stated that a notifiable disease shall mean an illness sustained by any person resulting from an infectious or contagious disease, an outbreak of which the competent local authority has stipulated shall be notified to them. Now, if you go back to the regulations I referred to that was promulgated in terms of the National Health Act, the national government there declared a respiratory disease caused by a novel respiratory pathogen a notifiable medical condition. So that if this condition is spotted in a person, the person or the doctor who makes the diagnosis must report it to the local authority by law. The insurer, so the court found that, and that is in fact what the regulations stated, and we all can agree, and the court agreed that COVID-19 falls within that definition of a disease caused by a novel respiratory pathogen. The insurer furthermore, in this case, admitted that COVID-19 is an infectious disease, and also obviously there was an outbreak of it in South Africa, and furthermore admitted that the virus was present within 50 kilometer radius of the business. Now, I don't know if any of you know where CAFÉ CHAMELEON is situated, but it is in fact situated about 200 meters from the Panorama Clinic in Tygerberg in Cape Town. And that area, that whole area in the northern suburbs of Cape Town was in fact at the time the epicenter of the disease. So I suppose it's not hard to see why the legal team of the insurers in this case conceded that the virus was present within 50 kilometers of that business. Now, the main dispute in this case was basically the relevance of the fact that it was well known that a local authority did not declare this disease as a notifiable disease. It was in fact declared by the national government. The second, in terms of those regulations, the 27 regulations that I referred to. The other main dispute was causation, whether the outbreak of COVID-19 caused the business interruption or basically the closure of the business, or whether the lockdown that occurred was a separate, distinct event that closed it. The argument of the insurance companies was that this was a lockdown national-wide, and it basically had nothing to do with COVID-19 in the specific area. The court furthermore, in order to get to a answer and in order to make the declaratory order, those provisions obviously has to be interpreted, the provisions of the agreement. And then there in law many rules, so to speak, for interpreting contracts. But the three important ones that came out in this case, in which the court applied is that you mustn't look at words in isolation within a contract. the purpose for which the provision has been inserted in the contract must be considered and actually plays a pivotal role, and the clauses must be interpreted sensibly and not have an unbusinesslike result, as the court put it. So provisions must receive fair and sensible application as far as possible. Now, using those rules and tools of interpretation, the court found that the notification requirement, that is now that it must be reported or notified to the local authority. The reason why it is included in this policy and in the extension is that the cover is only triggered for the most serious outbreaks of the disease. And having that in mind, the court further found that if that is the reason for it, then it cannot really matter what the source of the reporting obligation is, whether it's a local or the national government. The reporting obligation was there in terms of law. It was just that this law was not promulgated by a local government, but in fact by the national government. And then finally it held that it was in fact a notifiable disease, and I've already alluded to that. Previously, COVID-19 falls slap bang within the definition, one of the definitions in the 2017 regulations. The other point of dispute, as I've just referred to, was causation, and that is whether COVID-19 in fact caused the business interruption or a lockdown. And all courts, or in our law with causation, you look at two aspects. You look at factual causation and legal causation. Factual causation, you say, but for the peril, would the interruption have still occurred? The court found that the lockdown was the direct result of COVID-19, and business interruption was a direct result again of lockdown. But because the one would follow directly on the other, you can't think away COVID-19 without thinking away lockdown. The court found that there is a direct factual relationship. I mean, if it wasn't for COVID-19, in this case, the business interruption would not have occurred because there would not have been a lockdown. It's as simple as that. And then the court turned to the legal causation, and there you almost look at policy considerations. You look at the remoteness of the consequences with COVID-19, in this case, to the business interruption that occurred. The court found that the consequences was not that remote, and it was also fair and reasonable that the consequences be actually be attributed or let the policy kick in, and so to speak, be attributed to the insurer. Now the important part of this whole discussion, this talk, is the impact of this judgment. What does it entail? To get to that point, we must just remember that the insurance company has applied for leave to appeal. So if leave for appeal is granted and the appeal is successful, then obviously the impact of the judgment would be very different from what the situation is at the moment. But assuming that the appeal is successful, then policyholders with the extensions, with the infectious disease extensions falling in the category of the radius and notification category and in the notifiable disease category, may have reasons to smile. But as I have said, and it was stressed in the court decision, the facts and the circumstances of each case must be considered, and also the specific wording even within those categories of policy extensions. Just for instance, to look at the facts and circumstances, let's compare a CAFÉ Chameleon situated in Panorama and a restaurant sitting, situated in Pitsonnewater, and there's not one single case of COVID in Pitsonnewater, then the policy will definitely not, or no indemnification will occur in terms of that policy for the restaurant in Pitsonnewater, because it would not fulfill the radius aspect of the trigger element in that policy. So yeah, each case must be considered on its own. We'll have to wait and see if there will be a floodgate of claims. It's difficult to say, but yeah, some policyholders will definitely have a reason to feel will be assisted if this judgment stands. I also just want to point out that this judgment is in line with what the FSCA have suggested or actually stipulated to the insurance companies. So it is in line, because they basically said that the notification requirements in both the radius and notification category and the notifiable disease category, they consider as unfair and should not really be enforced. Yeah, and that's it from me. Let me just close that and sure.
Eugene, first of all, thank you very much. I think it was incredibly helpful, detailed, and there's a lot of information in there to work with. You note the FSCA. I'm going to come with a different angle to this. Worldwide, and specifically in financial services, the principle of treat your customer fairly, the principle of a broker or insurer or an advisor treating their customers fairly is a principle that worldwide is gaining traction. Now, given what you say about the FSCA in terms of the notices that they've issued and their comments, where does treat your customer fairly fit into this process?
Yeah, thank you for the question, Theo. Yeah, it's actually central to this issue. Although treat your customer fairly, the principles were not mentioned, and I'm actually a bit surprised that it never was specifically mentioned in the CAFÉ Chameleon case. It is central to all aspects of financial services, as you correctly stated, and also for the interpretation of an agreement and the handling of claims specifically. The FSCA has specifically said that the insurance companies must consider treat your customers fairly principles when they consider business interruption claims. And one must remember that the the treat your customers fairly actually creates obligations on the insurance company. It's not just airy-fairy principles, but it's actually enforceable. It's contained in the short-term, this policy, the protection rules that's been promulgated, and then there's also an act, I've got it somewhere, the Financial Sector Regulation Act, which specifically refers to to treat your customer fairly obligations. So it is central. There was in the CAFÉ Chameleon case reference made to fair treatment, but it was in the context of that it must have a business, not an unbusiness-like result, as the court put it, and people have to be treated fairly. And as I've said, the FSCA definitely looks at that, and in fact, they have said that the insurance companies must treat claims, with those principles in mind. They must handle it in that way.
Thank you, Eugene. Just, is there any questions at this point from anybody in line? If there's a question, please unmute yourself and ask the question. If there's no questions, I'll give a minute or two. I want to just ask a follow-up question on that. Yes. Clearly, this is not, Eugene, this is not a South African issue. This is a worldwide issue on two, and I want to ask on two scores. Number one, on the score of what is happening in the rest of the world, because I already see that there's various cases, not only around this, but various cases around it, number one. And number two, do you have, on that question in terms of international, do you have any idea of what the approach or the feeling of reinsurance on that? Because most South African insurance company obviously lays or sells part of their risk to international markets. Where are they on it? So first of all, what's happening in the rest of the world? And then secondly, in terms of the reinsurance market, what's the feeling on where we stand on this process?
Yeah, thank you, Theo. Yeah, I know that in Europe, in France, there's actually the same issues have come up, and there's court cases running on that, specifically with business interruption policies. And then at the moment, there's a case. Well, it's as we speak, basically running in the UK. I think it started on Monday, this week Monday, where the Conduct Authority in the UK has taken 8 insurance companies to court, basically also for a declaratory order. And what they've done is they've taken those companies' insurance policies. So the court is actually going to look at 8 different wordings of policies with these extensions for infectious diseases, and make rulings on them as to whether it's applicable in their in their field. But what is interesting from a South African point of view, for instance, this notifiable disease extension that was covered in the CAFÉ chameleon matter, the wording of that that extension has been borrowed straight from the London insurance market. So there's big similarities between them. So I can just imagine that this case in the UK would be of great importance for us in South Africa, although we must, well, firstly, it's not binding on our courts, but it will have big persuasive force, I'm sure, because our courts also would look at what's happening there. So it is going to be very, very important. Then you asked me about the reinsurers. I'm not sure what their attitude is, to be honest. I think they're holding on tight to their purses. Yeah, but I'm not sure. But I mean, if there is a flood, and with the reinsurers, I mean, that's an international market. If things, they are probably more looking now at what's happening in Europe and in the UK court cases than what's happening here. But yeah, it can have huge ramifications. If you, for instance, look at what happened with the asbestos cases with the reinsurers many years ago, I mean, it crippled them. So there's they would definitely not just want the insurance companies to belly up on it, I'm sure, because it's not in their interest.
Gina, I just want to go back to what you're saying in the UK. So the UK, it's not a restaurant or establishment that's taking the insurance to court. It's actually the regulator. Do you foresee that we might see at some point something like that in South Africa, or would you rather foresee it will depend on the outcome of the UK court case?
Yeah, I don't really foresee our regulator doing it here. I would see, because they've got a mechanism in South Africa where they can issue directives to insurance companies how to interpret specific policies. And what they've said in their notice to the insurance companies is that if they don't want to play ball, basically, and do not want to implement the TCF, the treat your customers fairly principles, they're going to issue directives showing them the way basically. And if one of those, if they receive a directive then like that, it's basically like law. Although the insurance company can go to the tribunal, the financial tribunals, so they can run that process, and they can also have their decision, if they're not happy, be reviewed by the court. So it can still be a long process as well, but I can't see them on behalf of, I think it's unlikely that they would take the cases up on behalf of policyholders, as is the case in the UK.
Any questions from the audience? Is there anybody with a question?
Eugene, it's Nadia Vet.
Hello, Nadia.
Yes. I want to, is this really a legal solution for the insurers? I mean, I can't see that this is a case for them, that there's any positives that can come out of it. If they lose, it's got to be bad for them. If they win, it's going to be bad for them. Just the reputational damage on this.
Yes.
Let's just take a practical business view and just make an offer to all the people that they think has got a valid claim. A 50% offer on that. And the second question is, how big is the impact really on our short-term insurers as far as this is concerned?
Okay, let me, the first one, if they have, I suppose you're right. It's a very difficult situation for the insurance companies because of reputational damage on the one side, and if they win, maybe. But yeah, it's going to be difficult for them to make ex gratia payments, so to speak, to settle. They will have to look at the costs. I'm not sure how big I'm not sure how many of these extensions are in the marketplace. I know that a few years back there were very few of them, and I think the insurance companies became almost maybe blasé, I don't know, because these extensions that started creeping in, more of them. So yeah, I'm not sure, but they must have made their sums and probably thought that it's not worth paying out, on a business principles, and rather just try and settle with the guys who they feel fall within it. The second part, just what's the second part there, Nadia, again?
Just what do we actually know what the impact of all of this will be on the short-term insurers? I mean, and specifically what you've just said, if it's not really such a big issue, the reputational damage that they will suffer far outweighs the actual claims that they've got. And I mean, as a lawyer, this is now the time for the insurers to settle, because businesses want this cash flow. I mean, they will take it.
Yeah. Yeah, look, the other thing is with these business interruption policies, all of them, most, if not all of them, state that if a business goes bankrupt, they've got no further obligation to pay. So it's critical for companies that they get their money before it goes that far. But yeah, getting to your reputational damage, look, the insurance market in South Africa, if they all are bad, I suppose you still have to insure somewhere. That may be, you still, if there's only 10 to choose from or 15 to choose from, and you're angry with all of them because they all have the same stance, you still have to insure somewhere. In this CAFÉ chameleon matter, the insurance company, the legal representatives of the insurance company made a big meal of it, that it will open the floodgates. They will go under if all these claims are entertained. But they didn't even supply proof of their own, their own position, leave alone the industry. So it is very difficult to say, and that's one thing that the judge found as well. He said, but listen, these guys, you haven't told us what the implications are of this. If you haven't showed us really, and the judge basically said that these policy wordings are so different and he was of the view that possibly it might not be a floodgate, because you still have to, as the example I've mentioned, I mean, the restaurant in Water is still not going to have a claim if there's not COVID close to it. And also the wording within each category might be, there might be bigger differences that they're not going to pay. So I've never seen anywhere where you can say it is going to be a major problem, and that insurance companies will really suffer to the extent that it could jeopardize the insurance industry in South Africa. I haven't seen anything like that. No.
Perhaps let me just, Nudia's question is interesting. If this was a state-owned entity, or if this was a politician, they'd ask for a political solution, trying to find a political solution. But just on that, what I do know is, Nudia and Eugene, is I've got from good authority that about 3 or 4 weeks ago, I know that the Prudential Authority, who looks after the capital requirements of the insurance companies, did ask them each individually for detailed analysis of the possible claims and the possible size of the claim. So I'm not sure what the end result is of that, but I do know that the Prudential Authority was in serious conversation with the insurance companies probably about 5 or 6 weeks ago to try to establish exactly what the risk is and what the capital position of the individual insurance companies is. But so it has been attended to. Somewhere there is a number, somewhere the regulator is looking at it, but I've got no idea what the number is and what the outcome of that was. So that's that. It is somebody did calculate this. I've just not got no idea what the answer is. But let me ask if there's any other questions. Then I want to, Eugene, I want to ask just a further question. You noted that part of any of these claims is around damages. What was the actual damages and how is it going to be calculated? Do you foresee that in this case, damages and the quantification of damages and the payment of damages, do you foresee that as being a stumbling block or a problem, that because something like that can also end up in court for months and years?
Yeah. Nadia would also know, Nadia being an advocate, that sometimes whole court cases are run just on quantum and quantification. So yes, I definitely foresee that there can be a problem, particularly if you look at the definitions in the policies, and most policies. I've already said that you compare, to get to the quantum, you compare the turnover in the indemnification period, which is now post-damage, basically the period while you suffer damage. So you take that period and you compare the turnover with a so-called standard turnover, which was now the turnover in the previous year over that period. So you look at that, but the policies all says that the insurance companies can make adjustments to that standard, and they can make the adjustments even, don't have to make it in the beginning. They can even make it post-damage. So what typically will happen, an insurance company will, in this case, say, but listen, the economy, due to COVID, is now so bad in any event that we can't just look at, we'll have to drop the standard basically against what we are going to measure your position against. So it's the COVID position we have to measure it against, not the standard of the previous year's period. So they can basically adjust that accordingly. And I can see that obviously will cause big problems. What is interesting is the UK case. This exact question is one of the questions, how that measures must be applied with the quantification as well. So even from that point of view, the UK matter, if judgment is given in that case, I think will be an eye-opener, because we haven't, I don't know of any cases that gone this far yet where you get to the quantification, but definitely it's going to be a problem. An interesting question, for instance, is if a business is completely closed down, you know, it's got no income, like a restaurant. Does it really matter what the position is regarding the rest? If it's partially trading, yeah, and how do you separate it? How do you determine what the market would have been if COVID wasn't around, you know, generally speaking? So it's going to be a difficult one. I definitely can see a lot of fights on that.
Then Eugene, 2 more questions. The first one is, in terms of urgency, I assume the court viewed this as an urgent matter and therefore it got heard. Do you expect that for a time being the court will have enough reason to believe these cases are urgent, or is that also something that might delay matters?
No, yeah, in this case, definitely. I didn't deal with it in my presentation, but it was brought on an urgent basis, and the urgency lies there in that, as I've mentioned, that these policies in any event falls away if a business goes under. So I think other courts will. I can't see any reason why it will you know, be treated differently, and matters like this will lose its urgency. I think in fact it will become more urgent as time carries on, because conditions will become more dire. It's as simple as that.
Right, then I'm going to ask if is there any more questions out there? I've got one more question, and first of all, is there any other questions? Anybody with a specific question?
Eugene,
Roelf?
yeah, just a question from my side while you were talking now. The urgency, I think, will stay there. You rightly mentioned if a company goes into liquidation for the end of the road. But what is the implication of, and we're seeing it, the numbers picking up of businesses being placed in business rescue? Would there be a different view to urgency on that?
Yeah, that's a good question, and it's a difficult question as well. If it's placed in business rescue, as far as I know, it does not. The policy will definitely not lapse. So that is something that can keep it afloat. But I still feel a court would see it as an urgent matter, because you know, if it's not a guarantee that if it's placed in business rescue, it's going to survive. The creditors will still have to, you know, the plans will have to be put forward, and you know, a lot of these places, like the business in the hospitality industry, for instance, sure, I don't even think they see the light at the end of the tunnel at this stage. I don't know how long it's going to carry on for them, because it's not just the fact that they can open partially now. That's also things like there's no liquor sales, and a large part of the income comes from that. There's all sorts of other things. So I don't think it would lose its urgency, but yeah, business rescue would mean that the policy would stay in place, I'm sure.
If there's no more questions, I've got the last one for you, Eugene, and I just want to congratulate you. I think it was well done. It was nicely rational, structured, and I really enjoyed it. My last question to you is, if I have a policy in this respect, and I believe I fulfill the requirements or the notices and the additions that you talked about now, and let's say my restaurant or my travel business is closed, but I do have what you talked about here. What would your advice be to me in terms of next steps, how do I approach it? What should I make sure? Who do I talk to first? What would your advice be to me if I'm in a position?
Okay, yeah, my advice would be, firstly, obviously, to follow exactly what is in the policy in terms of a claim. I mean, follow the steps, do it with, lodge it within so many days as the policy state, give them the information that's required, yeah, make sure you comply with exactly what you have to comply with in terms of the policy, and then push the insurance company for an answer. They will probably send out, I'm sure there will be an assessment done. An assessor will come out to see what the damages are. But then if you're unhappy with the answer you're getting from the insurance company, then you'll have to probably go and seek legal advice and take it from there, because I believe the ombud, there's the short-term insurance ombud, doesn't want to handle the business insurance claims because of the complexity. It's more complex, and it might also fall without their monetary limit, which I think was 3.5 million. There's 2 limits, but it's in that region. But the fact of the matter is, you're not going to be helped, I think, by the ombud, and so it would be best to advise business interruption sections, and business interruption insurance is probably one of the most complicated business insurance forms there is. I don't think there's, I mean, it's much more complex than, for instance, insuring against damage. So it is something that once you've made sure you followed all the loopholes or the loops to get to a claim, if there's a push them for a repudiation or a stance or where they are, and then you go and see an attorney about it and take it from there.
Eugene, thank you very much. I mean, I thoroughly enjoyed it. I think just one point, perhaps once you have the outcome of the court case in the UK, my understanding is, and from the deduction and my limited non-legal knowledge, is that will have a massive impact on the South African insurance industry. And given the fact that London is such a big reinsurer to our market, I think that will set the tone as to the way forward. And that will also set the tone as to the strategy of the FSCA. But from my point, Eugene, thank you very much. I think this was a great discussion. I think it's informative, well prepared, and very rational. Thank you very much, Eugene.
Well, thank you, Theo.
Is there something specific that you want to add today?
No, I think we've done 54 minutes, so I think it was a great discussion. I think it was informative, and I think I don't want to spoil it now to give a few to take the discussion in a different direction. I think this was a great discussion.
Yeah, Theo, I agree with you. On a good day, insurance and insurance policies and insurance claims and attending to the litigation is complex. I can reiterate what Eugene has said there. Those policies wording, it becomes difficult to understand and interpret, and to seek legal advice can only be a wise move. Kees, Snijders, CEO of Flickswitch, can I ask you to thank the parties and conclude our session?
Yes, thank you very much. So yeah, just on behalf of everyone on the call and those that will be viewing it on YouTube later, thanks first to vanderMerwe and Robertson for creating the True Normal platform. You treat us, I would say, more than fairly every week to quality, relevant information. Thank you, Eugene, for an insightful session. And I'm sure the fine print on insurance contracts is being scrutinized like never before. And thanks for helping us mere mortals understand and get some insight into the finer nuances of insurance legal speak. It is much appreciated. Thank you.
Thank you.
Thank you to all, and we see you next week, Thursday at 5 o'clock again. Thank you.